Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Roetzel and Andrews. I'm joined by Christina Kuta, who's a shareholder in the Roetzel and Andrews Healthcare Group. Today, we're going to be talking about some recent changes to Illinois law as it relates to behavior analysts and assistant behavior analysts. And these changes are really creating quite an uproar in the community. So we thought it'd be worthwhile to explain to everyone exactly what's going on. So Christina, tell us a little bit about these new legal requirements.
Sure. So last year, the Illinois Department of Financial Professional Regulation and state legislators instituted a new law. And that law now requires that behavioral analysts and assistant behavioral analysts have to be licensed in their profession no later than April 21st of this year. Prior to that, there were no specific licensing requirements for BAs and ABAs. Additionally, they instituted in statute that all entities that are formed for the purposes of providing BA or ABA services have to be formed as a professional corporation or a PC or a professional limited liability company, otherwise known as a PLLC, and can only be owned by licensed behavior analyst or assistant behavior analyst. That law goes into effect for the PC and PLLC requirements no later than January 15th, 2027.
Okay, so this isn't that crazy in the sense that many professions have to be licensed in Illinois. That's the first part. And many professions, like doctors are a good example, have to form either a professional corporation or a PLLC that's owned by doctors who are licensed in the same profession. So that part of itself is not necessarily crazy. The problem we get into, and I know you're going to dive into this a little bit, is that very often behavior analysts and assistant behavior analysts don't practice alone, either in their own entity or their own practice. They typically practice with other professions that also provide services, related specialties, mental health, etc. Right? So what issues are being created by this new change in the law?
So a couple different issues. Let's take the easier of the two first. So one is, what do you do if you have a business corporation right now, an Inc. or an LLC that's formed for the practice of BA or ABA? Do you have to convert to a PC or a PLLC? IDFPR's position, and it's pretty consistent with other professions where there have been changes requiring them to form as a PC or a PLLC, that you don't have to convert as long as you were in existence when the law went into effect and you're only owned by behavior analyst or assistant behavior analyst. So if you meet those requirements, you don't have to convert your entity. The bigger issue, and what's causing, I think, a lot of confusion is if you are a profession, let's say a psychologist, for an example, and you currently employ a BA or an ABA, can you continue to do so once the 2027 entity requirement begins, once the requirement that says if an entity is going to provide BA or ABA services has to be only owned by BAs or ABAs. The law itself is not entirely clear, but there is language in it that suggests it may be okay for a profession like a psychologist or an LCSW or an LCPC, for example, to continue to employ a BA or an ABA under this law. And there's been some guidance from professional associations, and we've seen some other chatter from lawyers that seem to suggest this would be okay. And it sort of goes with other professions where you have psychologists that will employ LCPCs or psychologists that employ clinical social workers, and IDFPR doesn't have any concern about that and doesn't seem to be a violation of the statute. However, we have actually spoken to IDFPR directly, to their legal department, and they are making the interpretation that as of 2027 date, January 1st, Their position is that BAs and ABAs will not be able to be employed by any other professionals. So if you currently are a psychologist and you have BAs that are employed by your practice, as of January 1st, 2027, you would no longer be able to employ those BAs in a psychology practice that's owned by a psychologist.
Okay, so the concern that's being created, obviously, is that this will create a lot of upheaval. There's a couple of positives. One is there's quite a bit of time before this would take effect. So we can definitely achieve some changes. There's two thoughts we had. One is it would appear that if these BAs or ABAs were hired as contractors and not employees, what do you think about whether that would be in line with what the department is saying?
So contracting is different than employing, and it wouldn't seem that the law would appear to prohibit that. One of the things that would have to be mindful in those arrangements would be the fee splitting provision, because there is a prohibition on division of fees and splitting of fees for BA and ABA services. So there would have to be some consideration given to how the fee is structured. But it would appear that, like, if a behavioral analyst, for example, started his or her own business and they started as a PLC, that a psychology practice, for example, could contract with that PLC to provide licensed behavior analysts services to patients of the practice. That would appear to be okay under the current law.
Okay. Now, I think one of the things that people need to understand is that one of the provisions in the law that allow different types of these licensed professions to practice together has not been expanded to include behavior analysts and assistant behavior analysts. And this is really important piece of it. Can you speak to that and how those changes might be achieved?
Sure. So the Professional Corporations Act and the Professional Limited Liability Company Act both have provisions for what we call related professions. So there's certain groupings of professions that allow those particular professionals, even though they have different licenses, to actually practice, own a practice together, and practice within the same entity. And one of the most relevant for the purposes of a behavior analyst would be there are related professions for psychologists, LCSWs, LCPCs, licensed marriage and family therapists. All these professions under the PC Act and the PLLC Act can own and operate a practice together. To this point, and IDFPR has confirmed they have no knowledge that there's a pending change, legislatures have not made any attempt to revise the current PC Act or the PLLC Act to add behavior analyst as one of those related professions. We believe that if those acts were modified and allowed behavioral analysts and assistant behavioral analysts to be deemed related professions to psychologists, social workers, LCPCs, for example, that the issue of employing these professionals would no longer be a concern.
Correct. And just to make it very clear that assumes that the type of profession wanting to employ them is on that list, right? So if you're in a grouping where it's made total sense and you're a multi-specialty practice to have a behavior analyst there, but in fact, you were never in that group to begin with, then part of the issue you'll have is that now it's a licensed profession and the rules might be different. So that until 2027, it is certainly possible that, this change could be achieved by them. And it seems like this is really where the focus of effort needs to be in order to clarify this issue. I don't know that the IDFPR is willing to take another look at this and clarify the advice that they've been giving out. I don't know if we agree necessarily with the advice they've been giving out, but at the end of the day, it's really their opinion on this that's going to matter if you want to be compliant with Illinois law, correct?
Yes, and I think one of the things people can do if they're concerned about this is talk to professional associations, talk to legislators, and see about trying to get an amendment made, either the amendment to that PC Act, the PLLC Act for the related professions, or some language that makes it very clear in the Behavioral Analyst Licensing Act that it was never intended to prohibit professions that commonly employ behavior analysts from continuing to employ behavioral analysts. My suspicion is nobody probably intended this to be the result, but it is the result in IDFPR's position, but it can be reversed and can be clarified certainly within the next 20 months.
Perfect. All right. Well, I think this is a really interesting topic for some people who are going to be listening to this. And hopefully it's been helpful if you're struggling to kind of figure out what's going on here. If you have any questions, feel free to reach out to Christina or to myself, and I'd be happy to help. Again, this is the Health Law Hotspot from Roetzel and Andrus, and we'll see you next time. Thanks.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.